Welcome to our webinar presented by Berkeley Select and the Hispanic National Bar Association. Today's webinar is entitled When a Complaint Hits What Every Attorney Should Know. We put together a great panel today, and it is moderated by April Toy. She is Executive Claims for HNBA. She's a HNBA National Executive Committee Vice President, a Wisconsin super lawyer. I get the pleasure of working with her because Hinshaw and Culbertson, her law firm, is one of our partners on the defense of our insureds, and also they run our risk management program. She is a proud graduate of Marquette Law School, and joining me is my distinguished colleague here over at Berkeley Select, Sandra Toro. She is a claims consultant for us and is a graduate of DePaul and has many years handling legal malpractice claims and also dealing with a lot of disciplinary matters that our insureds get into. So let's begin. What I did when I did some research into preparing this is I looked at two states that have a decent attorney population. The first state I picked to look at some data and gather is from Illinois. This is where I'm licensed and Sandra is licensed here. And some interesting facts. Over half of complaints, and this is according to the ARDC annual report, over half of the complaints result from former clients. So when I say former clients, that means something had happened with the attorney-client relationship. Either the attorney withdrew or the attorney was terminated by the client. So if that gives you kind of an indicator, when the relationship ends, sometimes they end poorly. So that leads us into our second bullet point. Not surprisingly, 64% are due to a deterioration in the attorney-client relationship. So when you are communicating with your clients and you get one of these, it's going to be very unfortunate when you see that little seal from whatever state you practice law in, and it's got the disciplinary commission or the regulatory or the Supreme Court notifying you that you've got a complaint filed against you. Chances are it's because you no longer have that client or you are no longer representing that client. The top allegation for all grievances, and this is the type of behavior, so keep that in mind, is neglect. So 1 out of 4 grievances or complaints filed against attorneys, unfortunately, are the result of neglect. So, one of the things we're going to talk about is how you avoid the spotlight and how you stay out of trouble. So just keep in mind that, if neglect is at the top of the list, that can be easily remedied. The good news for everybody, so if you've never had a disciplinary matter brought against you or a grievance filed or an investigation, only a very small percentage actually lead to prosecution. So right off the bat, 38% are closed without any disciplinary investigation. That would be, determined by the board or the regulatory body to have no merit at all. And most of those that are closed within about 60 days. So there's really no need to panic because the odds are really in your favor when it comes to disciplinary proceedings. So what I'd like to do now is talk about what can get you into trouble. And we're going to talk about what can get you into trouble. And we're going to also talk about certain areas of law that kind of seem to be recurring themes for disciplinary matters. So April, I know you have some concrete examples. You represent lawyers. Do you have a good story to share with us?
I do. Actually, but before we go into the story, I'm just going to touch a little bit on each of these categories, what rules are triggered, and really what we're talking about. So starting with neglect, as Al mentioned, that's going to be one of the top things that we see come across our desk. And neglect really doesn't have a precise definition, but what we most often see is neglect is going to be triggered by rules 1.3 and 1.4, which is diligence. You know, procrastination is one of the big ones that we'll see in the neglect cases. Communication as well, avoiding your client's calls, things of that nature. Competence, that's rule 1.1, and that rule basically states that the lawyer must provide competent representation, which entails having the requisite legal knowledge, skill, thoroughness, and preparation for the representation. What we're going to start seeing, we're probably going to start seeing a lot more of this rule 1.1 with AI becoming bigger. So comment 8 to rule 1.1 is talking about lawyers understanding technology, its benefits, and its risks. Oftentimes what we see under the incompetence charges are going to be attorneys who have maybe dabbled in an area of law that they're just not familiar with, and then therefore they make a mistake that they otherwise wouldn't if it was one of those areas that they were familiar with. Failure to communicate, that's a big one. We all know when your client calls, just call them back, be upfront. If you haven't done something, just tell them you haven't done something. Fees or billing, fees need to be reasonable. You need to make sure that your fees are set forth in the engagement agreement properly. So for instance, contingency fee cases, most states say you have to put that in writing and you have to put the percentage in writing. Otherwise you might be, in some cases you might have to there might be a dispute after the representation about collection, and you might be stuck doing something like unjust enrichment, and what you thought you were going to get isn't going to be the same amount, or you might not be able to collect it all because the court will say, listen, this is an improper fee agreement. Mismanagement of
April,
funds.
may I interrupt? I'm sorry. Can I ask the other two speakers to put their mic on mute, just because it sounds like one of our attendees is noticing a background sound. Sorry about that. Thank you so much. Go ahead.
So mismanagement of funds, that's a big one. Client funds are sacrosanct. Put them in your trust account. Don't commingle them. Don't use them for personal use. So to illustrate kind of all of these different top allegations in disciplinary proceedings, I'm just going to take one case that kind of had all of them. Really sad case, which serves as a cautionary tale, but it also has kind of a happy ending. Individual attorney, solo practitioner, about mid-career, who unfortunately ended up having a substance use disorder. Procrastinated, failed to get the necessary CLE requirements, and then was removed from the role of attorneys who were licensed to practice in that particular attorney's state. Continued to appear in cases, signed up a new client, took client funds. It was a small amount, hundreds of dollars, not even $1,000, but used that for personal funds, didn't file the particular pleadings that were necessary to get that case started. In another case, allowed failed to prosecute it, got dismissed, didn't tell the client about that. Then when the client got a new attorney, didn't really work with that new attorney, continued to practice in another case without telling the court or his client that in fact he had been removed from the role of attorneys who were licensed to practice for failure to get the CLEs. And so this the complaint alleged several different allegations: unauthorized practice of law, neglect of client matters, failure to prosecute, getting the case dismissed, not cooperating with successor counsel, conversion, mishandling of funds, dishonesty, had told clients that their cases were progressing when in fact they were not. And then obviously failure to communicate, wouldn't respond to client calls, etc. And so, you know, lots of cases, pattern of neglect. You know, it could have been much worse, but the aggravating factors were that this was not just an isolated incident. This was several cases, several clients, and ongoing pattern of neglect. So that was the aggravating factors. Mitigating factors, the individual went into a treatment program. Full cooperation with the governing body. There was a causal nexus between the misconduct and substance use disorder, and the individual went into treatment, completed the CLEs, got the license back in good order. There was a suspension, but most of that suspension was stayed, assuming that there was compliance with staying sober and keeping that license in good standing by completing the necessary CLEs. So, you know, what we learned from this is, number one, if a complaint comes in, be proactive, don't ignore it, and be forthcoming. If there are mitigating circumstances, own up, be remorseful. And so that was really a best case scenario for the attorney. Oh, you're on mute, Al. We can't hear you, Al. So I'll go ahead and jump in while Al's getting his mic off of mute. So in this slide, we really just laid out what the various areas of complaints, what areas of practice the complaints came in on. And as you see at the top is domestic relations, personal injury, property damage is number 2. Real estate, landlord, tenant falls below that. And you can kind of see as the cases, and I think it's like the top 10 areas of practice as they progress.
This is a list of ways that you can prevent the spotlight, meaning prevent as much as you can getting a disciplinary complaint filed against you. Even the best attorney, as the original slide indicates, can get a disciplinary complaint filed against you. You know, it's an occupational hazard. So if you're prepared and you know that one of these might come, you can best defend yourself. The first one is, as April indicated earlier, some of these are repetitive, but they're so important that it's good to keep these in mind. They all basically involve the breakdown in the client management, communication, and basic office systems. So the first one, as April alluded to, was do not neglect client matters. Make sure that you have an effective internal system to track client information, statutes of limitations, pleadings, and other deadlines on your desk. Make sure that your technology is current. You want to make sure in this day and age that you avoid a cyber attack. And finally, you should have a tickler system to give updates to your clients. Even if they don't ask you for one, it's good practice. The second one is communicate clearly, consistently, and honestly, just as April indicated earlier in her example. Initially, when you're first meeting the client, discuss the facts, set clear expectations, be realistic, look out for red flags. If you have a client, a potential client that criticizes a prior attorney or has unrealistic expectations, determine whether you want to keep the client. And if you decide you're not going to keep the person as a client, send them a letter and stating, you know, it was very nice to meet you, but I cannot represent you for whatever reason. And if there's a case such as a personal injury case where statute of limitations is coming, make sure and put that in the letter, because that person may later file a complaint against you stating that you didn't inform them about a statute of limitations issue. Communicate throughout. Once you decide that you're going to keep the client, communicate throughout the representation. If the client calls you, as April indicated earlier, return the call, the email, etc. If there's a change in circumstance, such as an unexpected ruling, something that changes the representation, advise your client. It's better to deal with those things during the representation so that you don't get a disciplinary complaint filed against you. Disclose fees up front. She already talked about it. Be clear. Is it a flat rate, contingent? Is there a retainer? When are payments expected? Answer questions. Safeguard client funds. It's so important, and to safeguard those funds. Do not commingle the funds with your personal funds. I mean, those can be one of the most serious ethical breaches that an attorney can commit. And a lot of states have instituted rules to really monitor those. And then maintain proper licensing in the state that you work in. And if you're practicing in another state, make sure that you're properly licensed in that state. Make sure that people in your office do not practice law. I know there are some states that allow it for certain activities. Just make sure that you know what the laws are in those states. Use engagement letters and disengagement letters. Those can help you tremendously if a complaint is filed against you. In the engagement letter, put in the scope of representation, the fees, billing, so that they can know exactly what you're representing them for. And the disengagement letter is just as important as the engagement letter. It delineates when the representation is complete. And it ends the attorney-client relationship. Be careful, because sometimes, and we see these on our desk, a former client will call and ask a question. And sometimes in our community, there might be a communication issue. They will think that you're still their attorney. Something goes wrong, and later on, they'll file a complaint against you. And it wasn't covered in that disengagement letter. If you're going to represent that client in a new matter, make sure that you write another engagement letter. And bottom line is document, document, document. This is not just best practice, it's critical. If it's not documented, it did not happen.
Great, thank you. I think I'm back now. We'll talk about what you can do now with the coverages that you have. When you're looking at coverage, you're going to definitely want to make sure that you have disciplinary coverage. It's usually set forth in the disciplinary proceedings section of your policy form. So I used a sample from Berkeley Select here. So your disciplinary proceedings typically, and this is, I'm speaking generally for all coverages for malpractice, first and foremost, a deductible usually does not apply to this. So that's good news for you. definitely communicate with your insurance carrier if you do get a disciplinary complaint that comes in, because what you're going to want to do is work with them because you are entitled to reimbursement. Sometimes those fees start somewhere around $10,000 that you would be entitled to, and this would be for responding to the complaint, paying fines if you are fined. I would say on average, the coverage probably is about a $50,000 sublimit. It could go up to $100,000. So just make sure you're checking your policy form and or talking to your agent or broker about the coverage you have. I know that this presentation isn't about claims, actually. It's more about disciplinary proceedings, but disciplinary proceedings could result in a claim. So make sure when you're looking at your coverage that the claim portion would be covered if it arose from a disciplinary proceeding. So these are just important notes to take when you're looking at your coverage. And keep in mind that disciplinary proceedings are always defined in a policy form. So it's just basically very broad. It means any matter that's brought against you before a state or federal licensing board or peer review committee. So make sure that you're looking at your coverages, make sure you have coverage for this, and make sure that you're talking to your carrier about these coverages. What we're going to do next, we're going to have some Q&A, but what we want to do is make sure that every participant gets a chance to scan this code and take a minute to share your insights about lawyers' malpractice and professional liability insurance. So we are giving away prizes. So you could be one of 5 winners for a $100 Amazon gift card. You don't have to complete this now, but if you scan this, you'll have this up on your phone and you will be ready to participate. What we're going to do right now is turn this over. I'm going to stop sharing this because we are going to hopefully have some engaged Q&A. So if anyone has any questions for us, you can use the bottom Q&A screen or chat screen. So we'll wait a couple minutes to get that loaded up.
I did get a question through the chat, and it is, can you share any more horror stories?
I bet April has a lot more.
So I do have some more horror stories. But you know, I think probably one of the most relevant ones now is AI. I certainly don't want to bring up one of mine, but I'll talk about one of the most well-known cases, which is the attorney who practiced AI. It was a New York case. It's the Matas case, I think. Or maybe I'm just thinking of that because that's our incoming president-elect. But so in that particular case, it wasn't a disciplinary hearing, but it was a sanction in court. The attorney was, and it actually brought up, again, triggered several of the different rules. One was diligence, one was candor to the tribunal. So gentleman was not familiar with federal bankruptcy law, took on a case that was probably more complex than he was able to handle, and then used ChatGPT to draft a brief, submit it to the court. Unbeknownst to him, it had hallucinated cases and that were very favorable to him. Some were gibberish. And as opposing counsel started to review the case, what ended up happening was everyone was like, wait a second, we can't find this legal authority anywhere. And what the lawyer did was the lawyer doubled down. And you know, continued to insist that they were reliable sources. Later on, it came out that unfortunately the lawyer had used ChatGPT and that had hallucinated the cases. And so it wasn't necessarily only that the lawyer had used had used a new technology. It was also that the lawyer doubled down and was dishonest. It was that the lawyer had probably taken a case that was out of his competency area. Certainly, he was familiar with state law, not federal law. So that's, I think we'll start seeing a lot more cases like that as ChatGPT, as even legal AI comes up. For instance, our firm has an AI program that is geared for lawyers. It's a closed system, so there aren't privacy concerns. But it can be off. So I think we'll see a lot of that. If we have no other questions, there's one area of protecting yourself that I always really like to bring up. Carla, are there any more questions?
There is one more question. It's what is the most common mistake you see lawyers make when dealing with disciplinary actions?
So I think what we see a lot of is really arises from procrastination, avoidance. So really those 1.3, 1.4 are really some of the top complaints, which again, we had talked about, like neglect is sort of this overarching kind of catch-all. But what we often see is missed deadlines, failure to apprise the client of a significant development, failing to call your client back. Now, for instance, you might have an attorney who doesn't communicate with their client for 6 months. Maybe they have something going on, and then they get through whatever it is that's going on in their life, and then they start communication on no prejudice, no harm has happened. And so that wouldn't be something that you'd see with the disciplinary complaint. However, if harm happens during that time, that's when you're going to see the disciplinary complaints arise. My rule of thumb is always communicate often and thorough with your client. If something bad happens in a case, just let them know if you made a mistake. So as a risk management attorney for Berkeley Select, they have a hotline. And so oftentimes, and I'm one of the people who is on the hotlines, will answer these calls. And so, you can pick up the phone and talk to an attorney who is who does legal malpractice law. And the beauty of this hotline, that especially the one that Berkeley Select has, is it's confidential. So you pick up the phone, you introduce yourself, I write you down as a number. Berkeley Select never has any idea who the person is who called on the hotline. And I think you get about 4 free hours of legal advice. And how that usually plays out is somebody will disclose, will tell us about a mistake that's happened. And then we talk about, how to disclose the mistake. Whether you need to terminate the relationship or whether you can try and fix the mistake under informed consent. We can't provide you any coverage information, but what we can do is tell you the risks and benefits of reporting that claim. One of the most important things to remember is failure to report a claim to your carrier could potentially trigger a coverage issue. So you don't want to try and hide a claim from your carrier because you're worried about rates, because the worst thing that can happen is that you have purchased coverage and then there's suddenly no coverage because you haven't been timely and you've prejudiced the insured by failing to timely notice the claim. So I think those are kind of some of the things that we see come up frequently.
We do ask on the application through the underwriting process whether you have a disciplinary matter filed against you. We can find that out through public information, but it's always good to disclose that if you have that, just to be up front with your carrier. And if you do need the coverage, you know where to look in your policy form, and you should be able to talk to your claims consultant about the coverages that you have for these matters that come in.
We have several questions, if you don't mind. All right. Can you talk more about commingling funds in New Jersey? That is grounds for disbarment. That's number one. So I'll let you go with that.
Sure, I can handle that. It's a bright line rule, you know, certainly can be a grounds for disbarment. But you know, as we saw in my practice case, you know, that can be mitigated. Commingling funds is a huge no-no. Client trust accounts are there for a reason. It's expected that you strictly adhere to that. Any client funds needs to go right into that trust account. There's very specific rules even about the interest. What happens to the interest in client trust accounts? So for instance, here in Wisconsin, I don't want to go too much off the rails, but oftentimes the interest from the client trust account, it goes to what's called a WISTAF here in Wisconsin, the Trust Account Fund, and that goes to pay for legal services to underserved communities, things like that. So yeah, keep all client funds in that trust account, because if you don't do that, it's just a recipe for disaster.
There's another question I'm looking at. The Berkeley Select Hotline, is that unique? We're very proud of it. Like I said, we work with Hinshaw, so we work with April on this, and every insured with us has full access to it, and that is a cost that we absorb as the insurance carrier. So it's not a separate cost. It's included within the premium that you pay, and there are other benefits to working with Risk Manager, because you not only get pre-claims assist, but you also get ethics advice. There's a dedicated hotline that you call. And like I said, or I think April said this, it's completely confidential. So the carrier doesn't know about this. This is between you and the risk manager. So it's very useful because it also allows for you to access materials on a website we talked about engagement letters and sample engagement letters. So it's very robust. So if you are one of our insureds, you can look into that. And I would encourage you to do so.
Right. And getting on those sample engagement agreements, your engagement agreement is one of the most important documents in your representation of a client. Setting that scope, so important. As we become more diversified, as we become more specialized, I'm not competent in every area of law. And so I'll give you an example of a case that I had where I had a business law attorney agree to do organized operating agreements. And during that transition, the accountant suggested liquidating holding companies. Now that had adverse tax consequences, pretty big. And unfortunately, my client did not put a scope of representation in their agreement, and so it was open-ended. What that meant was, even though my client was not a tax attorney, suddenly they're facing a legal malpractice action, a disciplinary claim, and without that limited scope, saying, hey, listen, we're representing you on the operating agreement, we're not providing any tax advice. Suddenly they found themselves in hot water, because after the fact, the accountant's like, oh, well, I never suggested that. That was all the attorney. Now, if they had a bulletproof engagement agreement, that whole mess could have been avoided. So that's a really important thing. And as Al mentioned, on the Berkeley Select website, there are sample engagement agreements, so you don't have to reinvent the wheel.
There's one more question about trends. The question is there a trend with solo small firm practitioners versus firms with disciplinary actions? Definitely smaller firms have more disciplinary complaints filed against them. I personally don't think that's a function of smaller firms or solos getting themselves into more trouble. I think it's just there are more smaller firms out there than there are larger firms. I think, close to half of all attorneys in private practice are solo practitioners. I think, the benefits of, having a larger firm is you have some, resources available to you that may help you. avoid some of these circumstances that you're going to get into. But again, one of the things that I started, discussing before I, messed up my mute button was the odds are in your favor. So, one of the slides, and we can make the slides available to everybody who participated. If California, I think, had 18,000 complaints filed, and that sounds like a lot, but there are 200,000 lawyers in California, and only 60 of them got disbarred. So like that is really good. Those numbers are really good. So, this is something, what we wanted to do is present, people who've been through this before, and, they know that it's not as scary or as bad as it sounds. It's shocking to get that letter, but most of these do not result in anything. So the odds are definitely in favor. And if you follow some of the simple tips that we discussed today, you'll keep yourselves out of trouble. I don't see any more questions. Sandra, do you have any closing remarks or advice for everybody? Yes, the rate of winning is high. That was, someone just typed that in. Yes, the rate of winning is definitely high.
You're on mute, Sandra.
I'm sorry. Just follow some of these tips that we gave you today. As I indicated earlier, it's an occupational hazard. Just try to follow some of the tips, and like Al said in April, there's a very high likelihood that the complaint will go away.
Well, thank you everybody for participating, and we look to see everybody again in the future on another informative webinar.
And for those who will be attending the annual conference, Al will be in attendance as well.
I look forward to meeting everyone.